court is State versus Tyler. We are 1 minute early according to this, but we're right on time or a little late with the other, so let's just proceed if you're okay.
Thank
All
you.
right. You know, obviously that you'll have to the 15 minutes since nobody's arguing on the other side.
I do, Your Honor. Thank you. May it please the court, my name is Mark Ludwig. Rhonda Kotnick and I have the privilege of representing Mr. Tyler. I will, as a quick aside, say one of the reasons I got a hold of Rhonda and we decided to work this case together was all those years that Rhonda was so kind to our beloved dead peers. I thought it was fair that in this time an old guy helped her out. So I've taken that mantle. Around midnight on October 23rd of 2017 at the Halftime Bar in Akron, 2 men were shot, one was killed, one was wounded. Multiple counts and specifications were brought against Mr. Tyler. Ultimately, though, of what we complain is his convictions by election of the state for purposeful murder of a Mr. Hardison. That was 15 years plus 3 for the gun spec. 2 years for felonious assault of Mr. Comby, the man who recovered and who did not testify, plus 3 years for a gun spec for him. Those 2 gun specs were then consecutive, plus 18 months for a CCW concurrent, which is, I think, quickly disposed of by this court. The CCW, he was indicted for a 4th degree CCW, he was sentenced on a 3rd degree CCW, and the verdict form has no degree. The CCW conviction is a little obviously messy. I think if the court certainly has the option to say, well, he should be convicted of the least 6 months, that's done. We're not really here complaining about a CCW he's already served. The purposeful murder conviction is wrong for the reason that there was no evidence of a specific intent to kill the individual killed. Now, that would also handle the gun spec on that count. But on the purposeful murder, one of the things we mentioned in our brief was, interestingly, after the Rule 29 was denied, during closing argument, the state told the jury, we don't think that he intended to kill that person. We don't think there was a purposeful murder. But he said that during closing argument. So my learned opponent in her reply brief said, well, that doesn't count if you're complaining about the denial of a directed verdict, because it wasn't said until after the directed verdict was denied. If it pleased the court, the prosecution made an election not to go with a murder by a felony murder of that man. They elected, after they told a jury they didn't believe that he intended to purposely murder, after that, they stood in front of that judge and elected to convict him of a purposeful murder. Now, whether you give them another bite at the apple with the felony murder is a whole nother question for later unmessing. But they particularly made that election. It's not the trial court's fault, it's not a defense fault, it's not a waiverable thing. They told the jury no purposeful murder. The felonious assault is a felonious assault. The error with that sentence is singularly this. This is a very narrow felonious assault. It is a felonious assault by causing harm with a firearm. It's not this court's billiard ball case, which was fascinating reading, but nevertheless, you throw some billiard ball at somebody and you got a firearm in your pocket, you can commit a felonious assault with a firearm, even though you haven't discharged the firearm. I understand that. This is a felonious assault by reason of use of a firearm, and there is a gun spec added to it. Now, however artfully we want to dance, that's punishing twice for the gun. The gun is a necessary element of the underlying crime. It's not a deadly weapon where you have a knife in one pocket and a gun in the back. It's not a billiard ball. It is a felonious assault with firearm, alleged plus suspect of a firearm. That's punishing for that firearm twice. The other assignments of error concern identification. Obviously, this is a one-on-one show-up. And obviously, it's clear in this case that cell phone data was obtained without a warrant. Now, the trial court ruled that despite that lack of warrant, the police had an objective, good faith belief, a Leon belief, that they could take these items without a warrant. Well, since Riley in 2014, that's been pretty clear. The United States Supreme Court says you get nothing from a cell phone without a warrant.
So they had the order, but they didn't have the warrant.
They didn't have a warrant, okay? And again, they had objective good faith belief when they went in Mrs. Mapp's home without a warrant and took the pornography. And oh, by the way, if we would have gotten a warrant, we would have gotten it anyways. So the trial court did not address the inevitable discovery claim that my opponent makes for the first made on appeal. They argued that at the trial court level, but the trial court never talked about inevitable discovery.
But by the time you did go to trial, they did have a warrant.
Yes. Oh, yes. Yeah. Yeah. We went back and did it right, so that so you should allow the evidence in because there's nothing, because we did something wrong. There's no need to punish us. We went back and did it right. Your Honor, was that warrant obtained without the taint of anything? If it was, it may be all right. But if they used the same information that they used to get the court order, that information is tainted and can't be reused to obtain an original or a new warrant. That's why simply getting one later does not equal inevitable discovery. That's not the definition of inevitable discovery. Plus, with all due respect, you've got enough to do. You shouldn't be making inevitable discovery rulings for the first time on appeal. If you want the trial judge to consider that aspect, perhaps that's something you might want to direct. We hope not. We hope you just realize this stuff was suppressible. The second assigned error is the police expert. He works from a video of one guy. He enlarges photos. He takes the surveillance video, creates comparative exhibits with red lines and arrows, draws enlarged tattoo pictures to other pictures with arrows and says these are the same. But because he is not asked the ultimate question, officer, do you have an opinion as to whether or not this is the same individual? Because he's not asked that particular question, all of a sudden, it's not expert testimony. It's just he was showing them a bunch of pictures. Come on, please. Read that testimony. Look at those exhibits. That is a creation of the officer with his alleged photographic expertise saying, and remember, he begins from a selected individual. He doesn't begin from an array. He doesn't begin from unknown subs. He begins with somebody they've already decided is the shooter.
Well, isn't it on video?
Pardon me?
Wasn't it on video?
Yes, but not who was on video. There was a hooded man
Right.
on video. That's not who.
What's wrong with going around asking people, do you recognize this man? Do you know who he is?
Nothing's wrong with going around recognizing him if you use an array.
Why do you have to use an array then?
Because it's presumptively unconstitutional to not use one.
I'm
Period.
not trying to understanding that. Go ahead.
Okay, but because it's presumptively unconstitutional to identify other ways, right? Here's where I'm sure we're going to differ, Your Honor, okay? The trial court said this may appear to be a photo show-up, but it was really a request for identification of an individual name. Quote, Police knew who the shooter was. The only missing fact was his name, close quote. What? Slow down. Feel the logic of that statement. We knew who you were. We didn't know your name. What? If you don't know my name, you don't know who I am. It's that simple.
But why would you put a known individual, the likeness of a known individual, okay?
Better.
The likeness of a known individual in a photo array, and then confuse the issues by saying, well, now pick out who the person is, when you have it on video? That just doesn't make sense to me.
It may not make sense, Your Honor, but it makes constitutional sense, and often the Constitution doesn't.
So
Because you're not telling them who to identify with the array. When you take a particular picture you've already decided is the person, from the hooded person, and you say, who is this person? Now, if you had used a blow-up photo of the hooded person, that might be we'll leave that case for another day. That's not what happened here. They decided who it was and used his identification, his Ohio identification picture to show to people and say, who is this? Listen to the logic again of we know who you are, we don't know your name. Go sell that on the street to anyone. Please, it is, and you look for years for this quote, the opportunity to, I think, fairly use it. When told in court that the law supposes his wife acts under his direction, Mr. Bumble replied, if the law supposed that, said Mr. Bumble, the law is an ass, an idiot. Oliver Twist, 1838. When you say to someone, we know who you are, we just don't know your name, Mr. Bumble has arrived.
Well, wouldn't you say, wasn't the state's position that the person in the hood was the person who did the shooting?
Yes, it was.
Okay, and they were just trying to identify who was the person in the hood?
Yes, they were. But they did
Would the
not.
photo array have to been a bunch of pictures of people in hoods?
No, but what the photo array should have been is a bunch of people who looked like who they believed was in the hood.
They
Okay?
got that person's name from those 4 witnesses.
They did. And had those persons been shown an array, and had they said, that's the guy I was with that night, that's the guy that was in the hood, totally different story. Totally different story. Okay? Fairly identified. Your Honor, it is troublesome because, God bless trial counsel, Mr. Whitney made it even better when, at the close of all the evidence, then they switched to self-defense, which I thought was masterful, although unsuccessful. But and I don't know, should this court vacate and send it back, I don't know as I stand here, I hope I'm not appointed, but whether or not the defendant's prior testimony, now in this case, could be used against him later, who knows? What is proper in this case, and you can count on one hand the number of times I've done this in this court, but what is proper in this case is that the conviction for 2 years for felonious assault certainly seems unassailable. A conviction for felonious assault with 3 more for the gun spec for the same gun is wrong. At best, what stands is the 2 years for the felonious assault, and we try and do it fairly on remand on the other charges. If the court has no further questions, thank you.
Thank you. We will take the matter under advisement and issue a written opinion that will be sent to both the state and the defense. Thank you so much.
Thank you.